Hello, and welcome to FLCC's 2023 Constitution Day program. I'm Professor Eric Duchess. I teach American history and political science here at the college, and I am joined today by Professor James Valenti, who teaches in the criminal justice program. And today, for this year's program, we thought it would be interesting to talk about some of the ways in which the U.S. Constitution goes to great lengths to protect the rights of citizens and criminal defendants in such cases. And we would like to focus in today on the Fourth Amendment, the Fifth Amendment, and if we have time, we might broach the Sixth Amendment a little bit as well. And I thought we would talk about why we have a Fourth Amendment to start things off. The Fourth Amendment basically states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall be issued except upon probable cause, supported by oath, and particularly describing the place to be searched and the persons or things to be seized. This was, in large measure, a reaction against the pre-revolutionary era in which the Parliament and the King were giving special, what were called writs of assistance to ship captains and customs officials and other royal officials in the colonies, whereby it was essentially a mobile search warrant that could be used by its holder on anyone, anytime, anywhere, and for any reason, which effectively undermined the entire idea of a warrant. And the Fourth Amendment attempted to enshrine into the Constitution some protections for the citizen so that the default setting would be in their favor. And I thought perhaps Professor Valenti could talk with us a little bit about the modern day Fourth Amendment, how it applies to us in contemporary times regarding our privacy rights, so to speak, even though that's only an implied right, and our ability to be secure, not only in our own persons and papers and homes, but also now in the digital age, virtually, for example, with our computers and cell phones in particular. So, Professor Valenti, could we ask you to talk a little bit about the Fourth Amendment with those ideas in mind?
Sure. And I want to remind everybody that, cases stand on their own and none of this is legal advice. What I want to do is I want to walk you through a little bit, as Professor Duchess just mentioned. In the colonies, these writs of assistance allowed, in effect, English soldiers to, without probable cause, go in people's homes, search where they wanted to, and it was an open writ. And it was argued against very eloquently in a colonial court by James Otis. And, well, he didn't win, but John Adams said that the seeds of the revolution, the fire was stoked there because people want to be in their home. A man's home is his castle. That's where that came from. They want to be able to feel secure. So, and if you look at the Declaration of Independence and you look at the Bill of Rights, the Bill of Rights was designed to answer the objections, many of the objections stated in the Declaration of Independence. So the Fourth Amendment says that no, in effect, it prohibits, and there's a long, long line of cases, but it doesn't say that you always need a warrant if you want to search. There are exceptions. The Fourth Amendment deals with both arrests and searches. It deals with the seizure of people, which is as an arrest, and the seizure of evidence. And it deals with searching. Now, as an overview, that we've had cases like the Katz decision in 1967 dealing with whether the FBI needs a warrant to put a wire on a public telephone on the outside of the booth. And the court said, yes, they do. We've had in the modern times cell phone cases, searching a suspect's cell phone without a warrant. We've had other cases where, for example, pat down, stop and frisk, Terry versus Ohio. Is that a search? So there are so many cases out there that deal with the Fourth Amendment. Now, the Fifth Amendment, the main ones there are now there are other ones,
Oh,
but of the criminal justice ones.
Professor, before we move
Mhm.
on, I did want to ask you about the landmark decision. This was from 1961, Map versus Ohio, and its implications on the so-called exclusionary rule. Could you explain to our viewers what the exclusionary rule is and how this case impacted the criminal justice system?
Sure. And MAP at first glance is a Fourth Amendment case, but I didn't talk about it there until I talk about the others. It was a search. It was a search without a warrant of Durley Map's home. But the broad ruling after that will be that the exclusionary rule, which is a rule which prevents, unless there's an exception, a court, what it really does is it prevents illegally obtained evidence in violation of someone's Fourth, Fifth, or Sixth Amendment rights to be admitted in a state court. Previous to MAP, illegally obtained evidence could not be admitted in a federal court, but they could be admitted in the state courts because the states weren't bound by that rule in a state prosecution. After MAP, MAP will revolutionize how criminal justice is done in America. Now, while there are some exceptions, I tell my students always ask yourself what the law was before the landmark decision and what it was after the landmark decision. And after MAP, the states are required, they are bound by the exclusionary rule. Now, did you want to go?
Well, I wanted to ask you also, are there some examples where the law does permit warrantless searches?
Well, you know, uh, here's the thing. Searches and seizures, as interpreted by the courts, do not always require a warrant. What they do require is that they be reasonable. They require probable cause. Now, there are exceptions to searching, like the plain view doctrine, they call it. Seeing something, law enforcement seeing something while they are lawfully at the looking post, it said. If they're where they're supposed to be and they see something, that is an exception. Okay. We have stop and frisk, uh, which is too long to unpack. Terry versus Ohio. We have things like consent. Sometimes people consent. Okay. We have search incident to a lawful arrest, etc. So while there are exceptions, that whole area deals with, in the Fourth Amendment, what is reasonable under the circumstances, and it also deals with, for example, the question is that a search? Is there an expectation of privacy? Is there an exception that's applied here? Okay. So there's a fair amount of analysis there with regard to the Fourth Amendment. That MAP case, just for example, that MAP case had sort of a wild set of facts. Law enforcement believes that she is harboring Dorley Mapp in Cleveland in a duplex. She lives in half. They think she's harboring, in effect, someone who put a bomb on the porch of an informant, a suspect that was engaged in that. They go there without a map. She calls her lawyer without a warrant. She calls her lawyer. The lawyer says, "Don't let them in. Don't let them search the house without a warrant." Law enforcement comes back later. They had dummied up a warrant. They pretended they have one. They really didn't have one. They go and they search anyhow. And before Mapp versus Ohio, that evidence would have come in. She was convicted. After Mapp versus Ohio, Ohio and all the states are bound by the exclusionary rule. So, what about from a civics point of view when people say Fifth Amendment? Excuse me, grand jury, right to a grand jury indictment, and there's a long history of that. Without going into that, probably the most famous one that everyone knows and they could recite are the Miranda rights, the right against self-incrimination, and also in the Fifth Amendment, a due process clause and the double jeopardy clause. A person cannot be put twice in danger of life or limb. I always thought that was one of the most eloquent terms and ways in which they describe that for the same crime, but there's a number of exceptions there.
I recall recently, although it might not be so recent anymore, that the new owner of the old O.J. Simpson property discovered a knife on the property. And this is, of course, long after the trial. And when that happened, I was asked by someone that, can they reopen the case? And no, under the double jeopardy rule, he had already been tried and acquitted for that crime. And under the double jeopardy rule, indicted again.
Ordinarily, that's true. Ordinarily, courts have said that newly discovered evidence is not grounds, is barred, I should say, prevents them from bringing it again. But if there's another exception, like a different sovereign, like sometimes if something is both a federal crime and a state crime, so, that may be brought.
Right.
The Sixth Amendment is just chock full of criminal procedure rights. The right, excuse me, years ago, I wrote a poem on it, and I would have to think about right now what it was, but the right to counsel, the right to a public trial, the right to a speedy trial, the right to cross-examine witnesses, and the right to of what we call compulsory process, which means if you're like, for example, an alibi witness, and that I didn't rob the bank, but you don't want to come forward and I'm being prosecuted, my lawyer can serve you with a subpoena and say, well, you saw him in the theater at 2 o'clock on Friday, and he couldn't have robbed the bank. So whether you like it or not, excuse me, here, you're going to have to come testify as an alibi. That's a defendant right.
You reminded me there of another Supreme Court case regarding evidence and exculpatory evidence, not testimony, but evidence. But the famous Brady versus Maryland case, where law enforcement is obliged to share with defense counsel any exculpatory evidence that favors the defendant, rather than keeping it
Yes.
hidden.
Yes, and I'm not sure here if I'm having a little technical difficulty. I may have to go plug in. I apologize for that. Something's coming up on my screen. So if I do that real quickly in a minute here, matter of fact, I might have to walk around to do that if you just give me a second here. But if you let me talk, I will tell you that in Brady versus Maryland, exculpatory matter was, now, what they said was that, well, we'll make it a podcast. That's a first ever, right? Half podcast. What they said was, it's unfair. You cannot play, in effect, hide the ball with evidence. You're the prosecutor. A prosecutor's first job is to do justice. It's not to just try to get a conviction. It's not to see how many notches someone could get in their belt. Their job is to do justice. So they had a duty to turn that evidence over to the defendant so that the defendant obviously would want that to be able to be presented. That was part of the 60s criminal justice revolution. And we have in that section from the 1960s Warren Court, and they got a lot of flack for it, the criminal justice revolution. The cases are greatest hits that come out of that. 1961, Mapp versus Ohio. 1963, Gideon versus Wainwright. 1966, Miranda versus Arizona. 1967, In re Galt. 1968, you have Terry versus Ohio. 1969, you have search incident to a lawful arrest is really part of that. It's sort of a memorable case. And somewhere around 1963 or 4, I think it was about 63, it's not important, you have that Brady versus Maryland as that criminal justice revolution. Most all of those except just one ultimately inure to the benefit of the defendant. And of course, they are innocent until proven guilty. So hopefully you could still hear me okay.
Yes, we can. But speaking of these rulings that are that were in favor of the defendants, you reminded me of the Fifth Amendment case. This was in 2010, Burgess versus Thompson, which ruled that a suspect or a criminal suspect must actively invoke their right to remain silent. Otherwise, their silence could actually be used against them. And would you see that as a part of a chipping away at that revolution of the Warren Court that you talked about?
Well, I will talk without getting into that one because it's been a while, to be honest with you. The thing about the cases are the more you do, sometimes you have to refresh your recollection. But I will tell you that today and over the last, well, really, if you say some of the 80s and 90s, there has been some chipping away, and in the 2000s, each case stands on its own. And we've had some controversial cases. For example, we've had one that you didn't hear too much about, but one of them was in Maryland, as I remember, it was Maryland versus King, where Maryland had a rule, a law that said that upon arrest, law enforcement, when they were doing their booking, etc., could, without consent, swab the inside of the mouth for DNA of the defendant, the suspect. And the case makes its way all the way to the Supreme Court, to SCOTUS, and you might be surprised to know that under that Fourth Amendment analysis, they found that was not an unreasonable search. That did not violate the Fourth Amendment, is an easier way to say it. As I can remember, and I have to tell you, I can remember distinctly on one of my journeys to the Supreme Court, on the way home, I usually read slip opinions on the plane, reading that opinion. And I can remember that there was if you want to look at a history of some of those, there was a very strong dissent by Antonin Scalia. He just didn't think this passed constitutional muster.
Well, I think you also raise and implied a very important point that when we talk about criminal defense rights and the rights of, limits on law enforcement, and so it's usually a simultaneous ebb and flow that we experience. For example, it was very
Right,
recent in the Ramos versus Louisiana case, where the Supreme Court
right,
ruled that in cases of felony convictions, you must have a unanimous jury.
right. And, in terms of modern law, they had upheld, as a matter of fact, I used to teach in my classes that a non-unanimous, a nine of 12 guilty on a felony was constitutional under the US Constitution. Now, many states had a rule against that, but if you were in a state like Louisiana that didn't, then you could be convicted by less than a unanimous jury. And the court, in an opinion, uh, as I remember, a majority opinion written by Justice Gorsuch, they struck down that uh, previous opinion. Uh, they reversed and said no, that you need unanimous.
What I've heard people question and wonder what, under the Sixth Amendment, a speedy trial means. Does that mean your trial has to be, start to finish speedily, or does that mean your trial needs to be brought to case without undue delay?
Well, in speedy trial, what you have is, in a speedy trial, you have the time when it has to start, the time when the prosecution has to be ready, and they call it people for readiness. So usually they have to be ready by a certain time, but it's sometimes it's not the prosecution's fault either. Sometimes it's the court that's behind. So those get kind of tricky, but you're right. It isn't at first glance what you think it is.
Well, Professor, I think we could go on hour after hour talking
Sure.
ins and outs of these various rulings. We've only scratched the surface, but I do hope that we have at least made
Right.
our viewers a little bit more aware of the ins and outs of criminal defense rights, the rights
Mhm.
that are afforded to us under the Constitution, and that this is an evolving and changing situation, and that
Mhm.
we do need to do our due diligence to keep abreast of what the courts say are our applicable criminal justice rights.
Yeah, each case stands on its own, and you know, I wanted to say, I don't know, do you say Happy Constitution Day? Um, September 17th. It's not one that people often hear about, but certainly very important. And I wanted to thank you, and uh, I always enjoy our sort of fireside chats here that we've been doing so many years.
Yes, thank you very much for joining
All
me
right.
today, and I'd like to thank all of our viewers who have joined us for this occasion, and hopefully we'll have something interesting for you next year as well. Thank
Bye.
you, and
Bye.
goodbye, everybody.